Hello, everybody.
All right, thank you, Mr. Kraus, for your patience, sir. We do have the attorney available to speak with you now. So what we're going to do is get you into a breakout room with him. You're going to see a prompt on your screen, sir, that says join. All you have to do is tap on that. So actually, you're both going to see that here. Sorry.
Okay, ma'am.
Okay, here you go. Both of you just tap on the join for me and you'll be able to talk privately.
I received the email. I'll discuss it with Mr. Kraus.
Okay, thank you. Okay, we got both of you back. So let's go ahead and get you arranged, sir. I have two files, as I stated, and I do live stream this to YouTube, but let me just tell you, when it comes time to get your personal information, I do stop the live stream, so that does not go out over the internet. That will remain private. So your full name, sir, is Christopher Charles Kraus. Is that correct?
Yes, sir. Ma'am.
Okay, thank you. And Mr. Smith, your appearance, please.
Yes, Your Honor. Tyler A. Smith from the Office of the Public Defender here in Ingham County. I appear on behalf of Mr. Kraus, who's appearing separately via Zoom today. I did speak to Mr. Kraus about the allegations against him, though honestly, I was not entirely certain based on the docket entry what either of the charges was. At any rate, we'll waive the formal reading as long as, of course, Mr. Kraus is aware of the general nature and penalty for each. Mr. Kraus, at any rate, wishes to plead not guilty to any allegation. I would demand the preliminary examination timely on his behalf, and he is seeking a public defender. I'm happy to address bond whenever the court may wish.
All right, thank you. So I'm not going to waive the reading because there's the two charges and then there's an habitual. So let's just go over it. 25-00577FY. Mr. Kraus, this is the people of the state of Michigan versus Christopher Charles Kraus, alleging on or about March 20th of 2024 at the location Holmes Road, City of Lansing, Ingham County, Michigan. Sir, count one alleges that you did buy, receive, possess, conceal, or aid in the concealment of a MacBook Pro, iPad, jewelry, clothing, and other home electronics and household items, stolen, embezzled, or converted property, knowing or having reason to know or reason to believe that the property was stolen, embezzled, or converted, and the value of the property was $1,000 or more, but less than $20,000, contrary to law. That is a felony, sir. Maximum penalty 5 years and or $10,000 or 3 times the value of the property, whichever is greater. The court may also order reimbursement to state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution. Sir, there is also a count 2 alleging that you did fail to comply by the Michigan Sex Offenders Act by failing to verify a registration address pursuant to the Michigan Sex Offender Registration Act. That is contrary to law. That is a high court misdemeanor. Maximum penalty on that is up to 2 years and or $2,000. There is also an habitual offender 4th offense notice on the complaint, sir, because you have 3 prior felony convictions. The maximum penalties may be enhanced from what I originally told you. So do you understand the charges rather, and the maximum penalties, sir?
Yes, ma'am.
All right, now you do have rights. You have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury, and at that trial you can present or confront witnesses. If they would not appear, the court can order them to do so. You also have the right to a lawyer. If you cannot afford one, one can be appointed for you at court expense. Additionally, sir, you are presumed innocent, and if you are found guilty, it must be beyond a reasonable doubt. And finally, you have the right to remain silent. Anything you say or write can be used against you, and you always have the right to have a lawyer present with you at any time that you are questioned. Do you understand those rights, sir?
Yes, ma'am.
Okay, good. Now, I understand that you're applying for an attorney. We have 2 hearings set for you. Sir, the first hearing is a probable cause conference that is scheduled for Thursday, March 20th. That is at 10:00 a.m. You're allowed to appear remotely by Zoom, or you have to appear in person. So we're going to get you the Zoom instructions and the notice to appear. Now, the second hearing, which is a preliminary exam, that is held the following Thursday, March 27th. That is at 9:00 a.m. with Judge Buchanan, and you must appear in person for that hearing date. So like I said, we'll get you that notice to appear and the Zoom instructions. Is there anything I've told you so far that you do not understand?
No, ma'am.
All right, thank you. I am going to stop the live stream. On a charge of attempt police officer fleeing and eluding from an offense date of March 25th of 2022. Sir, the bench warrant issued because you failed to appear for a probation violation arraignment that was scheduled April 3rd of 2023. Do you recall why you were not in court that day?
I was at court. I just what it was it's my first probation officer for probation meeting. I went to all my court hearings. It was my first time to see my PO.
Oh, okay, so I'm a little confused then. You said you were in court on April
Yes.
3rd?
Yeah, I went to see my I went and got sentenced, and when I got sentenced, they gave me a date to go see my PO, and I didn't show up to see my PO.
Okay, I think I'm still a little confused. You said you went and saw your PO, but then
No, I said I didn't go see my PO. I said when
You
Judge Ward,
didn't.
when Judge Ward sentenced me to probation, she gave me a date to go see my PO, and I didn't show up on that day.
Okay.
Okay, all right, thank you. Okay, so what I'm going to do is I'm going to arraign you on the allegations. So this is a request and summons for probation violation on a charge of, well, this says receiving and concealing a motor vehicle, so I don't know why that would have a difference. Trying to see what he pled on. Judgment of sentence. Pled to amended count 2, attempt. Okay, so it is attempt, fleeing, and eluding. That's what so this motion affidavit and bench warrant says that your probation officer alleges that the defendant has committed the following technical probation violations. Violation number 3, failed to schedule orders appointment with the probation officer. The amount of the penalty, sir, is dependent upon the number of violations. In this instance, you have 1 violation, which is on a misdemeanor, it's 5 days in jail. Okay, if there's a second violation or a third violation, or where you have an absconding violation, which means that you have been away from the court for a period of 60 days or longer, and it's described as a continuous period. Well, let me just read it to you. It'll make a lot of sense. Absconding is defined as the intentional failure of a probationer to report to his or her supervising agent, or to advise his or her supervising agent of his or her whereabouts for a continuous period of not less than 60 days. The reason I bring that up is because if you are charged with absconding, the maximum penalty can be the maximum charge on that charge of which you are on probation. So if you've already done some jail time, then they reduce that from what is,
No, man,
what
I didn't
is
do no
allowed.
jail time. It's kind of like this when you guys
We
send
wanna
me
be-
summons to come in.
Yeah,
wanna be
yeah,
very
no, you
careful.
don't. Mr. Smith is telling you not to talk, and
Oh, sorry.
that's a good thing, because you don't want to talk about this. You want to talk about it when you're talking to your attorney and not
Okay,
not to a court, and not especially when it's public. Okay, so I'm only going to tell you what those penalties are, but you also have rights, and I really need you to understand this as well. So you are accused, sir, of violating one or more of your probation conditions. You have the following basic rights. They're very similar to the other. You have the right to written notice of the alleged probation violations. You have the right to plead guilty, not guilty, or to stand mute. You have the right to contest the charges at a hearing, and certainly the right to a lawyer's assistance at that hearing and at all subsequent proceedings. At the arraignment, the court must inform you whether the alleged probation is charged as a technical or non-technical violation and the maximum possible jail or prison sentence. I've done that. Now, you have the right to a hearing set promptly. If it can't be set promptly, then the court must postpone that hearing. At that contested violation hearing, sir, the evidence against you must be disclosed to you. You have the right to be present at the hearing, to present evidence, and to examine and cross-examine witnesses. The court may consider only evidence that is relevant to the violation alleged, but it need not apply the rules of evidence except those pertaining to privileges. Additionally, the prosecuting attorney's burden of proving a violation is by a preponderance of the evidence standard. So that is a standard that is not as difficult to meet as you find in a beyond a reasonable doubt standard. Do you understand? Do you understand those rights?
Yes, ma'am.
Okay. All right, then, Mr. Smith, how is he pleading today to the violations?
We enter a plea of not guilty with regard to the allegations in the probation violation file as well, Your Honor.
All right, thank you. And is he applying for an attorney on this as well?
Yes, Your Honor.
All right, thank you. All right, so the court has set a date for you to appear. Your violation of probation hearing is set for Tuesday, March 18th, which is just less than 2 weeks. So March 18th, 1:30 p.m. with Judge Ward. So we will get that notice to you as well. And you do have to appear in person.
Yes, ma'am.
All right. All right, now, I already have his address, his phone number. I have everything that I need. So if you would address bond, please, Mr. Smith.
Yes, I'm happy to do so, Your Honor. My understanding is that Judge Ward, being the judge of record with regard to the probation file, has given an order such that Mr. Kraus would be remanded on that file while awaiting his hearing date. Understanding that to be the case, with regard to bond on the new file, I would simply request the court set a low 10% bond. I know I could go on and rage against something the court has no authority to change at this point. So rather than do so, I'll simply indicate this is not an allegation of any violence or anything of that sort. Well, of course, there may be some concerns. I don't think this is something where flight or a particularly grave risk to the community is contemplated. I would request a low 10% bond.
All right, thank you. So the court does look at your criminal history, sir. You do have the attempt misdemeanor police officer fleeing that we've talked about in the probation case. You have, other than that, you have convictions in like 1998 and 2000. So with that, I do find a 10% is appropriate. It is a $3,000, 10% bond with conditions. You cannot miss any court dates, and you cannot violate any state or local laws while you're on bond. You are not to possess, purchase, or consume any alcohol or controlled substances without a prescription, and you are not to leave the state of Michigan without permission from the court. Additionally, sir, you will have to report to pretrial services upon your release, and no firearms, ammunition, or dangerous weapons. And again, as long as you abide by those conditions, you would remain out on bond. Do you understand that, Mr. Kraus?
Yes,
All
ma'am.
right, then. Did you have anything else for the record, Mr. Smith?
I do not, Your Honor. Thank you.
All right, then, Mr. Kraus, that concludes your arraignment. You are all set. Thank you.
All right, Mr. Cross, you stand up, put your hands behind your back, put the back of your hands together.
Thank you so much for being here. Be safe, be well, sleep sweet, and much love.